this international seminar on trade secret as a momentous assets to be a grand success. I wish all of you and from the side of the speakers, I welcome all of you, and let me introduce one by one. Donald O'Connell, he is the Managing Director of Short Innovation Service Limited. Donald had a long career at Nokia for 21 years and has varied experience in the wireless telecom industry. And Donald is the former VP of R&D and Director of IP at Nokia. So he has a very vast and long experience in his career. He is the first speaker, and he will be speaking on very pertinent issue is trade secret and trade secret asset management. And he is also an adjunct professor at Imperial College London, and he'll deliver his lecture for 20 minutes, and question answer session will be taking up later on when all the speakers will finish their presentation. And next speaker we have Mr. Adarsh Ramanujan. Is an independent counsel with office at New Delhi and Chennai, and he has a very long work experience with Lakshmi Kumaran and Sridharan at New Delhi, and he obtained his BSc LLB, and he is a gold medalist from National Law University Jodhpur, and Masters of Law from University of California, Berkeley, and he is also qualified for a patent agent in India. So with this, I also welcome Mr. Adarsh Ramanujan, and our next speaker is Mr. Shubhadeep Sarkar. Shubhadeep Sarkar is the Assistant Vice President in Cognizant Technology and Cognizant Technology Solution. He has 20 years of experience working in diverse industries with a successful record of leadership accomplishment in both products and services industry in multiple technological domain, and he's also advisor and manage operational services on various corporates affairs processes, including the very pertinent and important issues intellectual property and technology licensing, commercialization, operational and governance and strategy. With this, I welcome Mr. Shubhadeep to be in this panel. And next speaker is Dinesh Jotwani. He has 25 years of experience and deep knowledge, deep understanding on policy, law, technology, litigation, government relation, especially in software, trade, IPR, and internet and cyber crimes. And he's the own managing partner of Jotwani Associates. And some of his noted includes his NCR Corporation, Technology LLP, Microsoft Corporations, Symantec, and Cisco. He holds 2 US patents and a lot of experience he has with that. I also welcome Mr. Dinesh Jotwani. And our MHRD IPR chair, Dr. Pinaki Ghosh. He is the senior advisor of KPMG, and now he is holding the MHRD IPR chair professor at WB-NUJS. With that, I request to Donald to start with his deliberation for this August gathering, and hope you will learn a lot of things from this panelist which we have with us now. And with that, I welcome all of you again. And myself is Dr. Jayanta Ghosh. I am working as a research fellow at the Center of WB-NUJ, Center of Regulatory Studies, Governance and Public Policy at West Bengal National Law University of Juridical Sciences. And with that, let's proceed with our first presentation. Donald, I request you to please proceed with your video, and please.
Hello, Pinnacle. Can you just enable the present, allow me to present my slides, please? Can you hear me okay? Hello, Pinnacle? Hello?
Yes, Donald, I think
we
can hear you. We can hear you.
Okay, good. Okay. Can you just confirm you can see my screen now? Can you see the screen okay? The slide set?
No, Donald.
Let me just share the screen. Can you see my slide set now?
No, not yet.
Not yet.
Okay. Let me just go back and redo this. Sorry.
Donald, we cannot see your slide.
Can you see the slides now?
Yeah. Yeah, it's coming. Yeah. Please go ahead.
Perfect. Okay,
Yes,
thank you. Sorry for that little hiccup. Okay, first of all, thank you very much for the invitation to speak today about trade secret and trade secret management. As I was introduced, yes, my background is I have my own company, Chart Innovation Services, since 2009, and we have a very strong focus on trade secret and trade secret management. And the rest you can see there. What are my experiences with trade secrets? Well, somewhat varied. My company, or the software part of my company, designed a trade secret management system, which we launched in the market in 2019. So we have experiences with dealing with companies using that software. We brought out a second software solution in 2019 that helps us analyze the maturity or sophistication of companies when it comes to their ability to manage trade secrets. We do a lot of trade secret training, and we even have some employee education videos in the market. I write regularly about trade secrets. I've had over 90 short papers published. We've been doing a lot of consultancy projects for various companies across different industry sectors over the past few years. So we've learned from working with those companies about what works and what doesn't work when it comes to managing trade secrets. We've been involved in a number of benchmarking exercises, comparing and contrasting how different companies are managing these assets. Oh, sorry. And we have formal relationships with a number of IP law firms and IP service providers in the area of trade secrets. Our technology is used by others, including such firms as Bird & Bird, Rouse, and CPA Global. Briefly, as I understand it, there are a number of law students as well as more experienced people on the event. The definition of trade secrets is quite simple. It is business information that is secret, that has value either now or in the future, and where you've taken reasonable steps to protect it. So unlike, for example, patents or trademarks, the definition is relatively simple, which has both advantages and disadvantages. So what does this mean in practice? It means that the information obviously cannot be in the public domain. If I can read about your trade secret on Google or in the local newspaper, then it's not a trade secret. You must keep it secret. This is an ongoing activity. Once it's no longer secret, it's no longer a trade secret. It must have value, as I said. You must control access. If half of India has access to your trade secret, then it's not a trade secret. But what is the absolute number depends on a case by case. The law doesn't say that 4 people having access is good and 5 people is bad. It depends on a case by case basis. You must protect your trade secret. And again, it depends on the jurisdiction, but more and more this is becoming to mean you must wrap the information in both in administrative, legal, and technical protection measures. You can share trade secrets with others. You can license them. But if you do so, you must have a legal framework in place between you and the other party, and the other company who now has access to your trade secret must also keep it secret. And then I would argue the trade secret must be documented. It is similar but not identical to employee know-how, what knowledge is inside in your head. In certain jurisdictions, this is absolutely clear, but in other jurisdictions, it's not so clear, this distinguishing between employee know-how and trade secrets. And then if we look at the negative, what is not required? There's no requirement for the information to be technical. Some trade secrets will be technical, but some of the trade secrets are non-technical. Financial information, process descriptions, raw data, cost information. There's absolutely no requirement to engage with the Patent and Trademark Office. You don't pay any official fees. Obviously, there's no requirement to publish it, unlike, for example, a patent. The information in the trade secret can be dynamic. It can be changing. For example, if you had a trade secret that was some software code, but you're continuously working on the code. So the trade secret is slightly different yesterday, today, and tomorrow, because it changes as you add new features or whatever. In many jurisdictions, there's no specific marking requirements. Do you have to put trade secret on the front cover? It depends. But in many jurisdictions, it doesn't specify that, but it may be good practice. There's no specific guidelines in terms of how you should document it. Unlike, for example, a patent, which is a very formal structure. But obviously, again, common sense would say you don't want your trade secret documented on the back of a cigarette packet. It should be professionally documented. And of course, the interesting thing about trade secrets is there's no time limit. It lasts as long as you keep meeting those requirements. It's got very broad scope. It really covers all the different forms of innovation: product, process, business, services. It can be a pattern, compilation of information. It can even be negative in the sense of it could be failed test data. Unlike, for example, a patent, you won't get a patent if your invention does not work. And here are some examples. These are taken from trade secrets that have been involved in court cases in recent times. And you can see that when you see the variety here, you see a mix of technical and non-technical. But I would argue that most companies have some of this information. Now, interestingly, trade secrets permeate an organization. You will find trade secrets in research and development, in logistics, in service. You'll even see it in corporate functions, the finance department, the sourcing and procurement department, the factory. They're not to be found just in one place. That said, most companies are not that sophisticated. Regardless of the size of the company and regardless of the industry sector, there are a few exceptions. Perhaps companies that have come from the defense or security sector, or some of the pharma type companies. But most companies do not have this well managed. I have been very surprised over the years about the types of companies that have approached me for help. One obvious challenge I see is that sometimes it's very difficult to go into an organization and find somebody who puts their hand up and says, I'm actually responsible for managing trade secrets in the organization. And of course, if you have no responsibility or no ownership, then it's very easy for something not to be properly managed. Even with companies who have in-house IP departments, intellectual property departments, I come across a lot of in-house IP managers who say that, yes, I am the IP manager, but actually I'm only responsible for patents and trademarks. Trade secrets is not my area of responsibility. which, by the way, I disagree with fundamentally. Now, because of fundamental trade secret law changes in key jurisdictions, in primarily the US, they changed their trade secret laws in 2016. Europe changed their trade secret laws in 2016, enacted in 2018. China, which has a series of laws on trade secrets, they've made some changes both in 2018 and 2019. And Japan has changed their trade secret laws quite dramatically in 2016. So this has resulted in lots of companies saying, well, we need to start taking trade secrets seriously. There are other reasons as well, not just the law changes. There's been more litigation. The tax authorities are more interested in intangible assets, including trade secrets. But a lot of companies do not know where to start. What are the first steps a company should be taking to manage its trade secrets? I would argue the first 5 steps are as follows. First of all, it is important that the employees in a company have a basic understanding and appreciation of trade secrets, because if you don't know what they are, it's very hard to manage them. There should be some sort of governance structure, some place where decisions can be taken, things can be monitored, budgets can be agreed, issues can be resolved. So there needs to be a governance structure looking after trade secrets. The company should have a trade secret policy. What is their overarching approach to trade secrets? Then it needs some sort of process. How are you going to handle trade secrets? How are you going to, first of all, identify them? How are you going to determine whether this information even qualifies as a trade secret? If you decide to keep it as a trade secret, how are you going to protect it? And going forward, how are you going to monitor that everything is okay? Particularly, for example, if you decide to share it with somebody else. And last but not least, the 5th step, you've got to start identifying and classifying these assets. If you don't even know what trade secrets you have, how are you going to manage them? And this is a challenge because, of course, in medium and large size companies, you may have lots of trade secrets, or you may have information which, if you manage properly, might qualify as a trade secret. The journey is really you're trying to get to from a point which down the bottom where maybe you have no policies, no governance and so forth, to a position where these assets are properly managed. And there's a maturity ladder that describes the journey as companies get more sophisticated and more mature when it comes to trade secrets. But like I said, a lot of companies are down towards the bottom, level 0, 1, and 2. Now, why do you need to manage your trade secrets? Or why are companies getting concerned about it? The obvious answer is that trade secret, if you think about trade secret law, is it protects you against trade secret theft. Either your employee stealing something, your directors or officers, your suppliers, your customers, your competitors, hackers, whoever. The law protects against theft. But there are other reasons why you might want to manage your trade secrets. More and more companies are embracing open or collaborative forms of innovation. They're working more with other companies. And when you get involved in a joint innovation project with somebody else, it's almost certain that you're going to share trade secrets with the other party, and they're going to share stuff with you. You might share specifications, technical documents, business plans, product roadmap information. They potentially are trade secrets. Secondly, companies are aware that the tax authorities are beginning to realize that the value of lots of companies is now the intangibles. And in those intangible assets, there are trade secrets. And if you look at some recent tax developments, there's a stronger and stronger focus on companies managing their valuable assets, including trade secrets. Trade secrets often come up when there are major corporate events, an investment round, a merger and acquisition, a joint venture. So again, having trade secrets managed helps with those sort of events going smoothly. Some companies are beginning to realize that they are in possession of trade secrets belonging to others. Your suppliers may have given you access to some of their trade secrets. Your clients may have given you access to some of their trade secrets. Well, typically in any agreements you've signed, you've committed to looking after these trade secrets, and you need to do so. And last but not least, I would argue that although patents are still very important, recent reform, particularly in the US, has weakened patents. It is harder to obtain a patent in certain areas. It is harder to keep your patent alive. In other words, it's easier for your patent to be challenged. And it's more difficult to enforce your patent, particularly in areas like software patents or business method patents. So patent reform in the US has slightly weakened patents. And therefore, some companies are thinking, well, are there alternative approaches? And also technology. Certain technologies lend themselves to being more protected by trade secrets, particularly things like algorithms or technology that's up in the cloud hidden away. Why patent it and have to publish? If I move away from companies and talk a little bit about IP law firms, trade secrets are also a challenge for many IP law firms. Many IP law firms are resourced with patent attorneys and trademark attorneys. So therefore, they haven't been trained on trade secrets. If you qualify as a patent attorney, it doesn't mean you know about trade secrets. They haven't any experience. They haven't worked with clients on lots of trade secret projects. So it's not just training, it's also experience. Some mistakenly equate trade secrets to patents very much. They see trade secrets and patents as two sides of the same coin. But I think that's a dangerous analogy because trade secrets are radically different from patents. Then the IP firms have the challenge, well, what services do I offer to my clients in the area of trade secrets? What am I actually going to do for them? It's easier with patents. I'm going to draft the patent. I'm going to prosecute it. I'm going to license it. I'm going to litigate. But what are the services when it comes to trade secrets? And then how do you price those services? Now, there are a few sophisticated IP law firms when it comes to trade secrets. They have determined that they will have a trade secret practice like a patent practice or a trademark practice or whatever. And on the right-hand side, I've listed some of the services that are now available from some of these IP law firms. And you can see there's quite a variety of things that they can do and offer. But it takes training and it takes experience to offer these services. These aren't things that can just be offered without any meat behind it. There are also others getting interested in trade secrets. We see a number of IP service providers start looking at solutions. Insurance providers are beginning to offer things like trade secret insurance. Aon, for example, have a comprehensive trade secret insurance offering. We see companies who are involved in litigation funding, where they finance IP disputes. They will now provide finance to trade secret disputes. So we're beginning in the last few years, beginning to notice that others are also paying attention to trade secrets. And like I said, the taxman is paying tremendous interest at the moment in two areas. In many European countries, we have interesting what are called patent box tax regimes that basically allow companies to reduce their tax bill if they can demonstrate clearly that they're innovative and creative. And in some of these regimes, trade secrets now qualify as an indication of innovation and creativity, not just patents. On the other side, the tax authorities are also very concerned about tax avoidance and tax evasion using IP. If you look at the OECD BEPS guidelines, they very much demand that medium and large size companies behave themselves when it comes to intergroup licenses and transfer pricing. And that includes the management of trade secrets. In the last few weeks, I've been involved, and I'm aware of a number of issues between the tax authorities and companies, and they're listed there. But if I look at what the tax authorities are worried about, it's about how these companies are managing trade secrets. Trade secrets is the primary focus of those examples listed. And last but not least, as we're sitting here today in our homes and our offices on this at this webinar, it's worth remembering something. There are people in prison at the moment in different parts of the world for trade secret theft. Because in many jurisdictions, it's not just a civil matter, it's a criminal issue. So you steal a trade secret, you can end up in prison. There's a person in Iowa State Penitentiary in the US at the moment. He's been in jail since 2019 for stealing a trade secret. So if you want to understand, is it serious? Absolutely, it's serious. But it definitely takes some thinking as to how to properly manage these assets. Now, I appreciate that my talk didn't make much mention of India, because my experiences are very much with dealing with companies in the US, Europe, and the Far East. But I'm aware that there's serious thinking in India about this issue. And of course, Indian companies deal with companies in these other regions, and some of the larger Indian companies are global in nature. In fact, some Indian companies have already been caught up in trade secret cases in America. Tata Consulting, for example, a big engineering company, has been involved in a dispute already in the US involving trade secrets, and there are others. And of course, the world these days is connected, so you can't just look at each country in isolation. But hopefully this presentation I've given you gives you a flavor as to what is it, what are the issues, and why are more and more companies now thinking about how do I properly manage these assets. Let me stop there and open it up to questions.
Thank you, Donald.
There's a question that came in on
Yeah, the
the
question.
question about failed test data. Let me give you a concrete example. In the mobile phone industry, there have been developments over the years. It started off at first generation analog systems, then second generation digital systems, and today we're dealing with fourth generation and fifth generation cell phone systems or mobile phone systems. Back in the early days of the mobile phones, the technical specification perhaps wasn't as well written or wasn't as robust compared to the technical specifications that now exist for fourth generation and fifth generation systems. And I remember that we were involved in a project where we had to check to see whether the different base stations out in the different regions were actually meeting specification or not. And we noticed that there were, in first generation systems in America, there were 11 different manufacturers of base stations. These are the masts that allow the mobile phone to communicate with the network. And many of the systems didn't 100% meet the specification. There were oddities or idiosyncrasies. And that information was negative. It was about how things failed, and hence it qualified as a trade secret. It was valuable information. It was protected, and it was clearly valuable because it took us time and energy to gather that information. So there are lots of examples of negative trade secrets. So let me stop there. I'll pass on to the next.
Yeah, thank you. Thank you, Donald. We're going to ask this question and answer session in the end of the sessions of after all the speakers.
Okay. Sorry.
Okay. Yeah. So our next speaker is Mr. Others. Others, are you ready?
Yes, Pinaki, am
Okay.
I audible and visible?
Yeah, you're audible and visible.
Perfect.
Go ahead.
Let me just share the. Can you see my slide deck?
Yes.
Yes.
Is my slide deck still visible?
Yes, it is visible. Go ahead.
Okay.
Yes.
Thank you. So good afternoon to one and all. And Thank you for the opportunity to share my thoughts on the topic. Now, I'm speaking on trade secrets in India, and I have to thank Donald for the great introduction on what is and what is not a trade secret, because that helps me cut through some of the stuff that I have to go through. A lot of it overlaps, at least the definitional part. So, my background is on the litigation side. I'm on the enforcement side of things. I have had the opportunity to represent plaintiffs who seek to enforce their trade secret. And I have also had the opportunity to defend companies who have been accused of trade secret misappropriation. So I've had the opportunity to be on both sides. So I kind of see where the enforcement is going about. So without further ado, let me directly dig into the topic. Now, in my opinion, Piraki, is my slide still visible?
Yes,
Yes.
it is visible.
All right. Okay. So I would say the recognition of trade secrets in India is quasi, meaning to say that as a concept, it has been recognized in several statutes. For example, it is taxed. There is an exception that is recognized in the Right to Information Act. The government authority can deny information under the Right to Information Act if it comprises trade secrets of a third party. But at the same time, unlike patents, trademarks, copyright, there is no separate statutory provision for the enforcement of trade secrets separately. So it is kind of quasi. There's been a lot of talk about the need for a legislation and so on, particularly in the light of some of the TRIPS obligations. But I can say from my experience, I've also had the opportunity to represent the government of India on several international disputes. The government of India's position, of course, before the WTO is that the current laws in India for the enforcement of confidential information are more than sufficient to comply with international obligations. So I doubt there might be any immediate move for a legislation to separately protect trade secrets. The last 4 bullets that you see on the screen suggest to you that there are in fact ways and means by which trade secrets are protected within India. One is under the equitable jurisdiction of courts. This traces back to a lot of English principles, English law principles. Concurrently is also your contractual obligation, your so-called non-disclosure agreements and confidentiality agreements. Of late, with all the digital information and most information being stored digitally, you have the Information Technology Act, which contains provisions directly or indirectly covering this issue. And last but not the least, we have our Victorian era penal code, which has been interpreted sufficiently broadly to cover some sort of data or trade secrets depending on the facts and circumstances of the case. So those criminal remedies anyway apply as well. Now, there are a lot of consequences to what I've just said. The first consequence is that uh, it is heavily dependent on foreign jurisprudence. In most cases, I have seen where trade secrets are involved, as much as we rely on Indian jurisprudence from the past. Those Indian cases in turn rely on English case law, and we as much as possible try to refer to the latest developments in English case law as well as on the American side, depending on which suits us given the facts. But there's a heavy reliance on foreign jurisprudence. Some people may consider this good, some people may consider this bad. I don't have any value judgment associated with it, but there are risks associated with involving foreign jurisprudence, because you will see this in the course of the presentation. Foreign jurisprudence develops in its own background, in its own historical context. So when you rely on foreign jurisprudence, you need to be very careful to what extent it would contextually and correctly apply in the Indian legal setup. Now, the second consequence is, more often than not, there's always a fight over what is or what is not trade secret. It's been an age-old problem for a long time. And not that this problem will go away because you have a legislation on it, because legislations also tend to have a more generic definition of what is or what is not a trade secret. Like Donald was mentioning, you will see this provision in the TRIPS agreement, which I've extracted above, which is Article 39.2 of the TRIPS agreement. And you will notice that this is largely, particularly the ones that I've highlighted in red color, if you can see on my screen, it is largely what Donald has defined in his slide as well. This is more or less an accepted set of requirements for something to qualify as a trade secret. The verbiage or the semantics may change, but the substance practically remains the same. Basically, you should have lawful control over it. It should have been kept secret. Its commercial value arises because it is kept secret, and that you have taken steps to keep it secret. Now, the third consequence, and this is probably the most critical consequence, I would say, of not having a separate legislation in India, is there's always a what I would call as a purported feeling that there's uncertainty and a lot of difficulties associated with enforcing trade secrets in India. Yes, there are difficulties in enforcing trade secrets in India, but that is equally true with all types of intellectual property rights. More often than not, the difficulty results from the overall lack of education on trade secrets and also the pendency of disputes before courts, which is more of a general problem plaguing the system as a whole. But what does happen is when clients have come back to me, or they've discussed potential cases, more often than not, uh, you have to educate them that there is a possibility of trade secret enforcement and that it might be done, it could be done. There are some limitations, but yes, it is possible. Clients immediately feel, well, it doesn't look that familiar, it doesn't look like there are too many judgments or jurisprudence on the topic, so is it worth spending the type of money and time enforcing trade secret? I've seen this type of body language as well as communication from clients over the years. So that's, I think, a consequence for not having legislation in India. Now, the other consequences I have seen is that usually because of this uncertainty element associated with enforcement in trade secrets in India, or at least the thinking that there is some uncertainty, usually a trade secret case is often combined with a breach of contract case or a statutory violation or copyright violation or something of that nature. You will usually not ever see an isolated cause of action for a trade secret violation. There are reasons for this also. I will, in the course of my presentation, I will show you a 2020 judgment that came out in May, which kind of highlights why people tend to do these joinder cause of actions, because there's always a risk when it comes to isolated trade secret enforcement. Now, the fourth consequence, I would say, is there's an alarming level of confusion when it comes to understanding enforcing trade secrets in the light of Section 27 of the Indian Contract Act, which I've displayed on the screen, as everyone might know, is a provision in the Indian Contract Act which states that an agreement in restraint of trade is void. On many occasions, I've helped a lot of startups and I've helped a lot of MSMEs also, drafting their employment contracts or high-level research persons contracts. They're always worried that if I put a clause on enforcement of trade secret, will I be challenged under Section 27? That confusion exists. I would say this is also a consequence because people generally tend to see, all right, so trade secret is a common law, non-statutory kind of a right, whereas you have a contract provision. Contract always overrides common law. The statute always overrides common law. That type of a feeling always sets in amongst clients. This is the fourth consequence I would highlight. Now, proceeding further, what I've seen from my experience and in law, you can sue a civil remedy under equitable jurisdiction and obtain an injunction not only against the violator but against any competing entity. Typically, when an ex-employee leaves with trade secret and joins a competitor, you could get an injunction. That is definitely possible. The limitation, as I said, is the fact that final disposition of litigation in India takes years. There are many cases that I was involved in the beginning of my career, but I know for a fact that they have not yet reached finality even today. So that's a big problem, which means the fight goes into interim injunctions. file a litigation initially and try to obtain an interim injunction. Hold on a second, please. Yeah, sorry. The problem there is, I will show this from one of the judgments down below, is the difficulty that a trade secret holder has in establishing what we call in law as a prima facie case. Now, under Indian jurisprudence, which is also borrowed from the UK, of course, in order to get an interim injunction, the plaintiff has to establish what is called as a prima facie case and demonstrate to the judge that prima facie he has some rights, and that if you do not give me an injunction, there's a strong reason why I will suffer irreparable injury, and that if it goes to trial, I'm likely to succeed on trial. You're supposed to show that you're going to likely succeed in trial. The problem with most trade secret cases is, in trade secret law, there is always a defense that I did not copy from you or I did not misappropriate trade secret, but this is a matter of independent innovation, which is you're entitled to have a defense of independent development or innovation. It's difficult for the plaintiff to establish everything before going to trial. And in many cases, injunctions are denied squarely for this reason. Now, off late, what has happened is judges have also, grown to this idea. So both parties are requested to provide details of their process, know-how, or whatever it may be under sealed covers for the view of the court. So defendants no longer can take the view that, no, mine is also secret. I have independently developed it. I'm not going to disclose it in court. You will be directed to deposit or inform the court about it in a sealed cover. So the judge can make his mind up or her mind up on whether there is actually a copy or not. There's actually misappropriation or there's no misappropriation. So that's changing a little bit now. Of course, you have damages, you also have search and seizure, and you have the age-old remedy of specific performance. Technically, in a trade secret type of a case, usually there are no positive covenants. It's more in the nature of a negative covenant to say that, okay, you are hereby prohibited, or you are not allowed or restrained from disclosing trade secret or using trade secret. So specific performance really doesn't come that much at a ground level. Now, here are a few cases. Now, the first case I would highlight is a very popular judgment, and it's often used by lawyers here as one of the seminal judgments that recognizes trade secret enforcement in India under equitable jurisdiction. Now, this was a fodder production unit, and this was an interim injunction case. This was also a joint cause of action for both copyright infringement for the drawings and so on and so forth, as well as for breach of contract because there was a confidentiality clause in the agreement in question. Now, in the course of ruling, the injunction was issued. The injunction was issued on multiple grounds. But in the course of giving that injunction, in the court concluding that there was prima facie case established for the grant of an interim injunction, the court recognized and approved a series of judgments, the most famous being Saltman Engineering from English law and all the progeny that followed thereafter, to conclude that it is possible under equitable jurisdiction to grant injunctions in case of breach of confidentiality or violation or misappropriation of trade secrets, which is independent of any contractual obligation, meaning thereby that even if there is no contract in place, you could still get that injunction, and independent of any copyright violation. So therefore, if your subject matter of trade secret happens to be something that is anyway not or otherwise not statutorily protectable, it doesn't mean that you are denied relief. This is therefore considered one of the most seminal cases as far as recognizing the enforcement of enforcing misappropriations of trade secrets under Indian law borrowed from English law. Now, the second case I would highlight, this is also an interesting case, is another Delhi judgment. This is also an interim injunction case. Now, here the issue was, or the facts were again, that there was no contract. Rather, there was a set of people the plaintiffs had disclosed and discussed over several meetings and written documentation, a concept note for a reality television program, for Swayamvar. It was a concept like a Swayamvar where a woman chooses amongst potential husbands, in a Swayamvar procedure. This concept note was shared, and subsequently it was shared under confidentiality that was established prima facie. but subsequently the broadcasting company ended up trying to put up their own show, copying that same idea and that concept. Suit was for copyright infringement and misappropriation of trade secret. There was no contract, there was no breach of contract clause. The court, in the course of giving that injunction, it recognized and approved that even though the concept of a Swayamvar could be public information in general, applying your mind to what is already available in the public and collating it into a single concept node with a specific script, with a specific format, with a specific structure, and so on and so forth, could independently amount to protectable trade secret. So the original underlying source could be public domain, but if you have applied your mind over it and established something over and above what's in the public domain, that is still entitled for protection as trade secret. It also approves and recognizes a very well-known principle in English law called as the springboard doctrine. I've given that quote from that English law, essentially to say that if some person obtains information from another person under confidentiality, it is unfair and inequitable for that receivee to use that as a springboard to do its own commercial activities to the detriment of the person who gave that information. This principle was applied and ultimately an injunction was granted, among others, on this principle. So this is yet another case where courts have recognized equitable jurisdiction to enforce trade secrets independent of a statutory violation and independent of a contract. Now, the third one, this is just an example to show that you could also have criminal liability associated with trade secret misappropriation. Now, here was a case where a company had illegally obtained copies of some confidential documents of another company, through various ways and means. And a case was registered under the Indian Penal Code, it's Victorian era legislation, as amounting to theft. It's a Calcutta High Court judgment. I'm just giving you as an example. The fight was whether documents, can be a subject matter of theft. Yes, a car can be a subject matter of theft. A bottle can be a subject matter of theft. A phone can be a subject matter of theft. But can a document be a subject matter of theft? The court interpreted the provision and held that for the purpose of Indian Penal Code 378, which is the provision on theft, so long as it's a movable property and you've caused wrongful loss dishonestly, it will amount to theft. And they held that a document would amount to movable property. They did, however, contrast that with information in the abstract sense. So, for example, if the alleged theft, the act of theft, involved a situation where I look at the document, I memorize its contents, and I leave. The fact that I've memorized and left and thereafter reproduced it may or may not amount to theft, because information is not property, but the document embodying that information is property. Now, there are also other provisions in the IPC, such as criminal breach of trust. For instance, you hand over confidential documents to somebody under trust and confidence, and they misappropriate it. That would also be another way in which a trade secret could amount to a criminal action, right? This is the third case law I would highlight. Now, the fourth one, this is not really a case law. The reason why I have not put cases is I am aware that there are several orders of this nature from the adjudicating authority under the Information Technology Act, under the provisions that I've listed above. One is section 43. Now, although the title to that section says compensation for damage to computer system, etc., if you closely read the subclause A and B that I've extracted, if you illegally secure access to a computer, illegally secure access to the email servers, you download, copy, or extract any data or information from such servers without permission, you are liable to pay compensation. And under 66, if you do any of that act dishonestly or fraudulently, that is with a criminal intention, that would amount to a criminal offense for which imprisonment and or fine can be imposed. I know for a fact that in Delhi, at least, there were a few orders passed by the adjudicating authority. Of course, they had dismissed a few cases also. And in Maharashtra, I know in Bombay, there were a few orders passed by the adjudicating authority where, ex-employees had left the company. They hacked into the email servers, tried to download information and data, and they were all fined 40 lakhs, 50 lakhs, depending on what quantum of compensation was assessed. So this is the fourth case law that I will highlight. Now, the fifth one is a very famous case, Niranjan Golikari. This is a case, this is one of those instances where we are now looking at the overlap of trade secret with contract law. All right. Now, a trade secret technically can be enforced in two different types of clauses. One type of clause in a contract is a non-compete, because the moment you tell a person that once you leave my company, you cannot join a competitor, ipso facto and automatically you're kind of inevitably precluding the disclosure of that trade secret, perhaps, So it's a non-compete clause. The other is a clause saying that you are hereby prohibited from disclosing my trade secrets. Now, this was a case where an injunction was issued on both clauses, right? But the most important difference is on the non-compete clause, the clause itself was only for a limited period of time. So here the contract of employment was for 5 years, and the person in question had quit after the first or the second year. So the court granted an injunction saying that, well, you cannot operate with a competing company for the remainder of that 5-year contract. The unserved contractual period you are bound to serve. In the course of that judgment, the court also held, however, that if an injunction had been granted beyond that contract period of 5 years, that would have been void under Section 27 of the Contract Act. Now, the most important thing that people often ignore when reading this judgment and understanding this judgment is that there was also a second part to the case where the injunction was granted against non-disclosure of trade secret, and this injunction was perpetual. This was not limited by time, this was not limited by territory, it was a perpetual injunction on the non-disclosure of trade secret. This was not challenged because it is accepted that you can have a clause restraining the disclosure of trade secret even beyond the employment term. The important point here, however, that the Supreme Court noted is, when you're giving this type of an injunction, you need to be careful in distinguishing between what is a trade secret that is protectable versus the knowledge, skill, and experience of a person which is otherwise not protectable. Now, good case for this is this judgment. This is actually a very old Bombay High Court judgment of 1946, but I find this to be an extremely good judgment. Very similar facts to Niranjan Golikari, right? Non-compete clause for a limited term, but perpetual non-disclosure. They cite this English case to differentiate between what is protectable as a trade secret and what is not protectable. They make that classification between what is objective, actual tangible items that you can identify, versus what is subjective, such as the aptitude, the experience, the skill, and so on and so forth that somebody gains. That part, they say, is not injunctable under equitable jurisdiction, whereas the objective part is injunctable under equitable jurisdiction. It's an important classification that we have to make when we go after, when a company has to go after ex-employees and so on and so forth for disclosure of trade secret. This is another good case if people are interested. When it comes to what is not protectable by trade secret, this was a case where an injunction was attempted to be obtained against a salesperson, right? And the plaintiff produced an exhibit saying that these are my trade secrets. The court said, come on, what kind of a list is this? You can't say vaguely policy decisions. It's like asking a surgeon to not do surgery. Obviously, a salesperson will have some innate skills and knowledge. Those types of things are never injunctable because they're not trade secrets. They are accessible. They are a matter of skill, knowledge, and dexterity. They are human skills. They can never be protected as a trade secret. So this is going to be the most important point for a plaintiff, to identify, specify what is trade secret and how it is different from the skill and experience of the human being that is involved. Now, the last case I will highlight, I'll just take one more minute. I think I'm exceeding my time by 1 minute already. I'll quickly go through this. This is the latest judgment in 2020 May. A seed company goes after another seed company because employees from one seed company have jumped to the other seed company. For those who are not familiar with the seed industry, there are typically parental lines or parental varieties that are kept as a secret. And from the parental varieties, you generate hybrids that are sold in the market. Now, the allegation was that these ex-employees stole this trade secret parental varieties and replicated and generated a different hybrid and sold it in the market. So the suit was for the misappropriation of the trade secreted parental varieties. Surprisingly, in my opinion, it's a totally erroneous judgment with all due respect. The court says that, well, in your case, there is no concept of, there is no pre-existing rights to your parental varieties, because there is a legislation called as the Plant Varieties Act. You should have gone and registered your variety under the Plant Varieties Act. You have not done so when it comes to your parental varieties. And to that extent, if you have no pre-existing common law right over your varieties, so therefore your injunction or your plaint itself is thrown out of the court. It's an unfortunate decision because it's very contrary to what we have seen in all the past provisions or in the past judgments. It's a little unclear. They have cited two or three, the learned single judge has cited two or three judgments of his own in the past to justify this order. Hopefully, we'll see some appeal to that goes into correction of this. That, I would say, is my last slide. And thank you very much for the opportunity again. And I'm told by Pinaki that we'll take questions at the end. Thank you.
Thank you very much, Adarsh. Thank you. So please wait because of the question answer session. Now I welcome Shubhadeep, Mr. Shubhadeep Sharkar of Cognizant. He will going to talk on the trade secret as a capital assets. Shubhadeep.
Yeah, thank you, Pinaki. Can you hear me?
Yes, we can hear you.
Okay. One sec. Can you see my screen now?
Yeah, we can see you.
Okay. So good afternoon, everyone. So, the earlier two sessions was very insightful. What I intend to cover in this session is how does a trade secret, how it can be treated as capital asset, which is extremely important, because end of the day, while what we have all understood is trade secret is very critical, but end of the day for a company, it should be monetizable. There has to be some value attached with it and some benefit. Then only, it makes sense for us to protect something as trade secret. Now, so just one starter, which is again told by both the earlier speakers, trade secrets are as important, but oftentimes is the invisible component of company's IP portfolio. And I'll tell you why I say this is invisible. But eventually, if you really look at it, in many of the occasions, trade secrets can become the crown jewels within your overall IP portfolio. Now, let's look at some of the basic definitions, both from a accounting perspective as well as what is an asset. Now, I'll not get into too much of details, but I'll just highlight certain important aspects which will come later in my slide. When you look at asset, it has to be separable and it has to have certain traits. For example, transferred, licensed, rented, or exchanged. These are important terms for you to remember because these will come in the later slides. Or it can be arising out of a contractual or other legal rights. That's one portion of what we mean by an asset. Now, if you look at some of the accounting standards, both the accounting standard 26 or IAS 38, it clearly says that an intangible asset is an identifiable non-monetary item without physical substance, which is within the control of an entity and is capable of generating future economic benefits for the entity. So when auditors or finance experts, they actually prepare a balance sheet or try to build the intangible sheet accounting, they'll keep these items in mind. And trade secret definitely falls under this because it meets all the criteria. But having said that, it also becomes a little challenging in terms of how do I really put a value, quantifiable value around trade secret. And I'll give you certain guidelines around how it is usually accounted. Now, if you look at the overall value management, and many of you would have seen this slide earlier, it is from J.B. Turner in 2003. Now, some of the important aspects, and I'll not get into too much details on the overall IP management, because this is more intended for an IP management slide. But the important aspect is, if you look at, and I'll give you perspective from industry, and because I belong to the IT industry, some of the examples will be from the IT industry. So if you look at any products, processes, or services, that these, what do you call? I mean, these monetizable assets, which are product, processes, services, will include a host of IP associated with it. One product may have a lot of patents, it may have trademarks, it will have copyrights, and also trade secrets. Now, these trade secrets usually, as Donald said in his first presentation, that most of the companies, when they say about IP management, they try and focus about trademarks, copyrights, and patents. However, trade secret forms such an important component, because nowadays, if you look at all the industry, and this is not just about software industry, all the industries, it's all about incremental innovation. It's all about making things better than what it was. Now, if you really try and understand what makes something better, you will see that majority of the time it is that small information, small pieces of these confidential information, business secrets, etc., which plays a very important role for a success of an innovation. And some of these may not, while they may be eligible for patent filing, but then patent filing has its own pros and cons, and I'll come to those aspects as well. So trade secrets and confidential information plays a very vital role, because these are embedded into the assets. It's embedded into the products, processes, which you cannot really see, but these are something that creates that differentiator with respect to a competitor. And therefore, it is extremely important to protect it in some form or the other. And that's why the overall IP value chain, if you look at it, trade secret in today's world plays a very, very crucial aspect. Sometimes in certain aspects, it plays even better or more crucial role than even patents, which gives a broader protection anyways. Now let's move to the next slide. Now, if you look at the traditional IP protection, when we talk about, let's say, a patent, I'm just taking patent as an example, there is an element of cost, which is not very cheap, right? To file a patent, get a worldwide protection, etc. It's quite an expensive affair. It takes a lot of time. There are legal complexities around. You have complex processes. You require a host of good, patent experts, patent agents who can work with the inventors to create a good draft, enlarge the scope of protection. Sometimes, you will also require a good amount of technology, platforms, tools, etc., to do a proper IP management. And then with the rapid change in technology and emerging business models, again, I'll use what Donald was saying, that in today's world, there is for any innovation, for any company, there is a lot of third-party dependency. You will have to collaborate with many people. You will have to use, open innovations, etc. So when you're doing these collaborations, there is always an exchange of information which is critical. And through this open innovation culture, you also start creating a lot of best practices. And these best practices are nothing but trade secrets. Not all of them, but majority of them. So therefore, while traditional IP protection is important, and I am not ignoring that at all, but at the same time, if you want to really create that differentiator in market, then you will have to invest on trade secrets. There is no shortcut around it. Now, let's look at some of the business value of trade secrets. The first section are some of the examples, and Donald, already covered most of them, if not all of them, in fact. But the important aspect is that when you actually have a trade secret, and I know there have been some questions, I was looking at the chat, we can address questions around why a negative information or failed experiments becomes a trade secret. Is actually a very, very vital, information. I have heard scenarios where in an R&D lab, when they're doing experiments for years, once they get what they want, the first thing they do is not to file patent on what they have done. First is to destroy the results of the failed experiments, because that's extremely important information, and we can talk about it during the question and answer session. But some of these are extremely important in terms of protection of trade secret and confidential information. Now, some of the advantage that you get, and these advantages in turn gives you a motivation to put a value and put a value associated with a trade secret and ensure that it increases the overall intangibles value for the company. So for any IP, for that matter, price premium is a very important aspect. You can charge a premium, you can save costs, you can create barriers of entry for your competitors. You can get thereby getting this competitive advantage. You have a lot of marketing advantages associated with it. Some of the IPs that you have can also be used in certain geographies and depending on the various processes. And India is also emerging into that kind of a regime where you can use IP as a collateral for loans, etc. So therefore, end of the day, trade secret should be treated as a standard IP model, which is not taken so seriously, primarily because it's not that people are not aware, people are aware, but what happens is that there is a process that you need to establish within an organization to manage trade secrets, and people feel that that is not the right way of doing, or they don't have that priority for doing the trade secret. But it hurts them when there is a misappropriation of trade secret. That is the time when they realize that they should have actually done good amount of investment on trade secrets. The other important aspect is because trade secret is also a form of IP which doesn't get registered per se. It is regarded that it's not an IP, which is wrong, because it can be protected well, and you can actually enforce some of the rights if you have a proper mechanism to protect it. Now, why value trade secrets? And this is again very similar to how you treat a normal IP. Normally, in a transfer pricing scenario, or during a mergers acquisition or purchase price allocation, or for accounting purpose, when you are accounting intangibles, that is the time when you have to put a value to your trade secrets. Trade secret licensing, you can actually license trade secrets, and I'll touch upon this a little bit in detail in my next slide. For litigation dispute resolution, or when trade secret acts as a very good differentiator for you with respect to your competitors, or for premium pricing, or for taxation purpose, etc. For all these, you actually need to value trade secrets, and that's how it acts as a asset for you, a capital asset. Now, if you look at valuation of trade secrets, typically, if you look at any valuation methodology, you have primarily three broad areas of valuation. You have the cost approach, and then again, cost approach, of course, depends on different models that people use. You have replacement cost theory, you have reproduction cost, and it is not about that the value is equal to the past or historical cost. You have to have certain calculations based on which you can derive the cost. Then the market estimation and comparison, you basically try and compare your asset with respect to a competitive asset and try to derive a value out of it. Income approach is another method which is the widely used and accepted method, wherein you basically use DCF kind of a methodology to find the NPV, and then you derive a value out of it. So basically, it's the future projection of a future revenue stream that you expect from a IP. That forms part of the income approach. Advanced methodologies are also there. You have real option methods, you have Nash methods, decision tree, and it goes on and on in terms of different advanced methodologies. However, the most predominant methodology which is widely used is the income approach. That's because in any valuation exercise, the idea is to reduce the number of assumptions. And one of the easy method to reduce an assumption is usually the income approach, because you have a good amount of data to back up. And this is a method or model that most of the auditors accept, primarily because the assumptions are the lowest. However, in certain technology areas, even within trade secret, you can use the cost approach or a market approach. So which model to use for valuing a trade secret depends on the type of trade secret. You cannot put everything under the same income approach and try to do a valuation. It will depend on the type of trade secret that you have, and that's how you choose the right model to value. Now, if you look at the accounting from an accounting perspective, when does an accountant really recognize trade secret as an asset which can get into your financial books? When it is identifiable, when it is controlled, it has capability to generate revenue or future economic benefits, and you have a cost and future revenues which can be measured reliably. So these are the 4 aspects and normal auditor will try to figure out when they actually accept whether a trade secret can be put as an asset, a real asset in the books of accounts. For example, research phase versus development phase. This is a challenge that most of the auditors will have. Now, when you look at the development phase, it is very clear. You have a cost associated with development. You have a future revenue, which you have projected based on certain costs, your marketing expenses, your collaboration expenses, so on and so forth. Now, because these are controlled, these are identifiable, and it is, it is more reliable, they will probably be agreeable to actually value at a development phase rather than a research phase where the assumptions are really very high. So that's one example I wanted to give you how these are treated, these assets are treated in the books. Now, licensing, again, some of the nitty-gritties around trade secret licensing, of course, is the scope of the license, and these are hard negotiation point before parties can really frame an agreement around it. So scope of license, term of license is extremely important. The territory, that's again a very important aspect. Sub-licensing rights, whether it's only you who should take the license or you have to again give it to your customers, etc. Royalty rate and payment terms, it depends on whether it is a staggered payment, it is linked to your fixed sale as a fixed percentage of your sales, and there could be other methodologies around payment terms. Transfer methodology, how are you going to transfer this knowledge? What is the risk sharing mechanisms around it? How do you retain the knowledge and distribute the knowledge? These have to be well documented because, again, going to what Donald was saying, that it is all about how do you maintain a trade secret. So if I'm licensing out a trade secret to a party A, he will have to meet certain obligations so that at the end of the day, it remains as a trade secret. If he goes out and starts publishing, writing books and papers, then it's no more a trade secret, right? Then derivative work. If somebody is doing a derivative work, who owns that right? How does that need to be maintained? Any restrictions and prohibitions, reps and warranties. These are primarily the issues of contention between parties when you go for trade secrets. Of course, the other clauses are also there, but these are the primary issues in trade secret licensing. Now, I'll take an example just to show, and I know that I'm already at 3:40, but I'll just quickly wrap up in another 2 minutes, where I just want to cover this case study on how non-compete, and the earlier speakers have also talked a lot about non-compete, so this actually goes very well as an example. So how do you value a non-compete in intangibles? So if you really look at a non-compete, there are 4 critical elements. One is the ability to compete, whether you have the financial capability, you have deep knowledge, and you have strong relations with customers, because these are factors which trigger a non-compete kind of a scenario. The second is willingness to compete. An age, entrepreneurial skills, your stated skill, amount, and length of earnout. These are important, which gets into the willingness of compete. Then enforceability. Can you really enforce? And Adarsh was talked a lot about, enforceability, etc. And then probability of competition. What is the difference between, and this is the critical point of valuation, what is the difference of sales or my business expectation with a agreement, non-compete agreement, or without a non-compete agreement? Because that differential is what is the value. And what I mean by that is that the next slide, and this I borrowed from a paper from Nandita Pai 2019. So what is happening is that you take the economic life in years, which is the number of years actually, the standard discount rate and the tax rate. These are important input components. Now, if you look at the cash flow, and this again boils down to the income method that I talked about, where you're talking about what is my expected cash flow with a non-compete in place and expected cash flow without a non-compete. And the difference is basically nothing but the incremental cash flow. And when I do a normal discounting and from a PV and find the the present value factor and discount it with a 18% or whatever is the prevalent percentage, then I get a value of the incremental cash flow. And then if I amortize it with the tax rate, I get the incremental value. And this value goes into the books as intangibles. And this is how you actually calculate everything. When you calculate a goodwill, or you calculate a trade name, or you calculate human resources in some certain instances, or things like non-compete in this case, you add up everything and that forms your balance sheet of intangibles. And that's how the overall market value of the company also goes up, because if you really look at the distribution of tangible asset versus intangible asset in your books, you will always find intangibles holding 70%, right, in a typical technology scenario. So this is one way of how, not only from a business point of view, how trade secret is important, but even from an accounting perspective, even from a valuation of a company perspective, trade secret plays such an important role. So last slide, my only recommendation is don't ignore trade secrets, because they can be the most powerful differentiators and assets for you. Thank you so much.
Excellent.
Well, thank you, Shubhodip sir. Now I request Dinesh, Mr. Dinesh Jotwani, please start your presentation.
Sure, I'll do that. Let me share the screen. Can you?
Yes, it's visible. Make it full screen. Yeah, perfect. Please go on.
All right. Thank you. Thank you so much for giving me this opportunity. We'll talk about trade secrets with a special focus on financial services industry today. Before we do that, quick introduction about myself and my law firm. I'm the founder of Jotwani Associates. We've been mainly practicing in the area of intellectual property rights, though we have a multidisciplinary practice. We have 3 offices in New Delhi and also associated offices in Bangladesh, Pakistan, Sri Lanka, Bhutan, and Myanmar, the SAARC region. Some of the practice areas you would see here are mainly focused on intellectual property rights. Of course, we also have civil and crime practices, which some of our partners take up. Again, very quick introduction. These are our partners. And as you can see, my personal experience is around 25 years, mainly focused on technology law. So this is brief introduction about my firm. I would now jump directly into the financial services and the importance of trade secrets in that. When we say financial services industry, it's a very wide term, but just to give little context to it, these includes all the commercial banks, financial institutions, payment wallet, payment gateways, hardware companies like ATMs, those who manufacture ATMs and point of sale machines, insurance companies, brokerage, companies, wealth management companies, even CAs who manage wealth management would come on the financial services industry. Why a special focus was required on the financial industry? Because they are the holder of the maximum confidential information, you can say. And I think, yes, they hold from valuation perspective, from the value of the data perspective, they hold a lot of value, a lot of trade secrets that has immense value to to themselves and to others also. Now, components of confidential information that a financial services industry may have, this may include the financial net worth of individuals, which is very, very important. It's important for other companies to know about financial net worth of individuals. When we talk about, companies who hold a lot of information, confidential information, or even personal information, you would see companies like Google or Facebook having a lot of that information. But do they have financial net worth of individuals? Maybe not. Maybe yes, and maybe not. So I think from financial services industry, that is their financial net worth of individuals, knowing financial that's very, very important. If that information leaks out, it can be disaster for the customer, for the financial institution, and for other institutions in that environment. So and they know the business secrets of their clients, of course, where they get the where they get their business contracts from, where they do business contracts. They will have all that kind of confidential information. Buying habits and preferences. They know exactly where individuals go and buy and spend their money on. So they have that information. They have the information on health parameters. This is what they are going to this particular hospital or this particular clinic, or spending money on this kind of health parameters. So they know all that information. They know whether it's a legal source or an illegal source. If there's a sudden money that comes into the bank account, they will, they might flag it to the law enforcement agencies and say that, look, this looks like a transaction which is an illegal source, which is of a huge amount. So these again is information with respect to their clients, which is again a trade secret which they should maintain. They know the geographical locations of their client, of course, where exactly they are, where they're spending money, whether they have gone to a particular city or a particular country. Again, financial services companies would know that. Of course, they hold a lot of personal information also, PII as they call it, is because they know the mobile, so they have to send OTPs and they have to, with all the registered email IDs and mobile number which they have, so they gather in the process a lot of personal information, which is again a confidential information from customer perspective. And of course, they know the social relationship of an individual also, where exactly they are going to, with whom they are interacting, to whom they are giving loans or friendly loans, or whom they are, spending money on. So all this information that they have with respect to customers, the banks would have that information. The companies like Paytm will have it, or the payment wallet companies will have all these kind of information. And so the value of confidential information maintained by financial services company is huge, and so is the responsibility on them to maintain that confidential information. We'll talk about some of the examples in the later slides. Why is trade secret ever rising threat in today's scenario? During pandemic period only, our law firm got actually three legal cases of trade secret theft happening. And I can say that all the three of them were from the financial services industry. Some of them maintained the credit cards, some of them even maintained credit ratings, and the information was taken by employees because people were working from home. They had access to a lot of confidential data, and it was always available to the employees when they were working from home, and it could be easily taken away. So just to mention that why trade secret is the disputes as far as litigation is concerning, they are increasing. Maybe the reason is we now have increased workforce mobility, traveling from one city to another. They have access to data from different sources. There is more sharing of the information also. There are information that is on the cloud. It can be shared among employees. It can be shared among peer industries also. Supplier contracts, vendor contracts. All this information is now online, and now there is more sharing of the information, which results in more leakage of the trade secrets, and more legal challenges for the organizations. Technology, again, I'll show why it's also a challenge, and it's also a benefit that the companies can use of. But yes, the technology allows very easy copying, downloading, transferring sensitive information very easily. Many times, people who are IT savvy can always delete that information also. It becomes ever challenging to know whether your trade secrets have been leaked or not. Again, the crime, they steal and selling of information for financial gain. That's another area that is worrisome now. And we'll talk about the Tata case later on. What happened in that is the biggest trade secret case that has impacted India. Outsourcing, again, when you outsource to foreign countries, there is a lack of control, which one should take care of. That's again giving rise to violation of trade secret and confidential information. Internationalization of transaction, that's again an area which is extremely sensitive, and now the banking and wallet transaction can easily be done from anywhere and at any point of time. This has given rise to a lot of challenges from maintaining the trade secret and the transactions that are happening across the nations. So these are some of the areas where I would say are challenges for financial services industry in terms of maintaining their confidential information and maintaining their edge over competitors. All right, I would just highlight this case, Epic versus Tata Consultancy, which took place in US. In fact, this is an old slide. Recently, this case was when TCS actually downloaded certain confidential information, health-related information of its clients, Epic, who had given them to develop a particular part of the software in India. Now that was done by an employee of TCS, but the case went on in US company where their vendor actually sued them. In 2 weeks, the judgment was out, and Tata was imposed with a penalty of $940 million, which has now been actually now this case went in on an appeal, and the quantum of damages have been reduced to $140 million US. This judgment came recently in August 2020 only, when the damages were reduced to $140 US. Now, many of these cases which take place, including the one I mentioned that happened in our law firm, when our clients approached, the challenges of enforcement in trade secrets cases is manifold. You can prove that, okay, yes, a theft took place. For example, the case that cited here, Epic versus Tata Consultancy, they could prove, okay, the documents were downloaded at such and such time, they were downloaded at such and such IP address. The quantum of document or the source code downloaded can be known. Person who has done it can be known. All these facts, it's maybe easier for us to prove that. But what is difficult is to prove the value of trade secrets. When the matter goes to litigation, how do you prove that? That what is the value of the downloaded data? Now, to give the live example of what happened in the pandemic period with one of our clients, they were credit rating companies, and they allowed their employees to work from home. And one of the employees downloaded their CRM, which they had developed from 1994. There was an in-house CRM which they had maintained from more than 2 decades, and it was, we had a whole team of 4 to 5 people who brought about new features into that. But the whole source code was downloaded by one employee who actually resigned and during the pandemic period and gave his laptop back. Now, we could easily prove that the source code has been taken, but how do we prove the value of that CRM, which has been developed over so many years? Some people said, oh, if you look at the cost of the employees working on it from so many years, maybe 2 crores, 3 crores, but what about the other kind of features that it had, and it was a multi-jurisdictional software that was downloaded. How do you value it? We valued it at 58 crore rupees, but there was no, to be honest, there was no proof for that. When we went to cyber cell and complained to the DCP, he actually mentioned, how do you prove that? And we had no answer to it, but of course, FIR was registered on that, and the case is still pending after the accused got the bail. Valuation was I think the biggest kind of a challenge in trade secrets, and whether what did he do? What did the accused do? How did he make money out of those trade secrets? Again, has this to be proved? It's very difficult to do that. In the example that I gave you, the employee that had taken the source code, did he give it to the competitors? What did he do after downloading that on the pen drive? We do not know about that. Okay, even when the raid was conducted and the pen drive was seized, could you know that it has been copied to another pen drive or it has been given to the competitor? We do not know that. And in fact, I was telling you about this. The biggest trade secret violation case of TCS. Here also in the appeal, I think one of the main ground that TCS took was that we do not know the value of it, and we do not know the employee who downloaded it, how did he misuse that particular health records that were with him. So in an enforcement and litigation, when it comes to the biggest defense is on the valuation of trade secrets. Perhaps one of the formulas that Shubhadeep mentioned earlier could be used to value them and given to the law enforcement agencies or used in the court to show that this is what the value of a trade secret is or a source code is that has been stolen by the accused. So this is these are some of the litigation challenges that we get.
So we can start our question answer sessions. So I request Pinaki sir, please take the charge of this question answer session.
Yeah, am I audible?
Yeah, you are, sir. Please.
Okay. Dinesh, once you're back, please ping here. We can reconnect. Okay, so I have a couple of questions now that I'll go one by one. Is first for the Donal. This is Mr. Arunabha Banerjee from NLU Jodhpur. He already asked, and I think you have already given the answer. The question I just repeat. He wants to know how a failed test result qualifies as trade secret. How does such information command value, and why does it need to be kept secret? Almost the same questions is from Anesha Piparia, that about that what are the negative trade secrets?
Yeah, I mean it's a good question, but I think it's been covered. But clearly, if you're a company and you spend time and energy putting together information, it could be a pharma or biotech company who's testing some chemicals, but at the end of the analysis, it's discovered the chemicals are toxic. Or if you're an engineering company and you're doing a lot of testing, but the test results are all negative, that information can be extremely valuable. Any engineer knows that you learn a lot from a failed test. So the trade secret law does not prevent negative information from qualifying. If you keep it secret, it has value because you spend time and energy compiling it, and it gives you a competitive advantage, and you protect that information with reasonable steps. Absolutely, negative information can be a trade secret, and that is true regardless of which jurisdiction you're talking about. So there are lots of examples in different industry sectors, food and beverage, chemical, pharma, engineering, where you can have very valuable negative information about things that did not work or fail or whatever. So hopefully that explains it.
Thank you, Donald. The next questions, Dr. Nina Sethi. He's asking a good questions that many of the undisclosed information, which is actually the traditional informations of the Indian subcontinent, those can be captured under the trade secret, and if yes or if no, and how openly it can be exploited by the Western nations.
Well, obviously, if you have traditional knowledge, and that's known by a large group of people, I may not be the best person to ask that, but my concern would be, would that really qualify as a trade secret? You may be looking at other forms of IP like geographical indications or things like that, but maybe I'll pass it to one of the Indian lawyers to talk about this. But I'm just trying to imagine an example of something that is traditional knowledge that would qualify as a trade secret.
Yeah. So I'll ask the same question to others, Dinesh.
Yeah.
Others, there is a in Lucknow, there is that author. So there is a group of people who has that knowledge of the making that the perfume, correct? The author of the Lucknow.
Oh, yes.
And that is a very traditional information that generation after generation they are keeping that one with them. And there is a large group of people who know that one, but it is within their village or within their relatives.
Yes.
Would that be qualified as a trade secret?
Yeah. In theory, if you look at the language and the ingredients of Article 39(2) of TRIPS agreement, I believe it can fulfill the condition, because 39.2 does not say or put a limitation that it has to be maintained confidential only within one person or two persons or three people.
Yeah.
It is open. So a community as a whole can keep it as a secret. Point number one. Point number two, to the best of my knowledge, and I'm open to correction, this might require some research also. I have read in the course of my reading for some earlier cases or something, it's just there in my mind, but I can't pinpoint specifically. There are cases in the US, I believe, where Native Americans have made such a claim. I think there are some judgments also. I seem to have come across it, but I can't be sure right now. So perhaps for the person who would ask the question, that's an area that they can explore. Definitely.
And by the way, there is an example in Europe. There's a group of monks who know the formula for a certain alcoholic beverage, and that is considered a trade secret because it's known by this group of people. It's very traditional. The drink has been around since the Middle Ages, I believe, but it's considered a trade secret because they keep that information within that group. It is never divulged. And so yes, there are, now that I think about it, there are examples of what the question refers to as sort of traditional knowledge that could qualify as a trade secret. Yes.
Yeah, and perhaps Pinaki, the second part of that question. See, nowadays, see, for example, in the Indian statute, we have a provision, section 3P, which says that you cannot patent something in India which is in effect traditional knowledge. Now, in countries like the Europe, they have now access to the database developed by CICR on Indian traditional knowledge, and they use that database as prior art to preclude anybody from patenting something in Europe which is actually traditional knowledge in India. So now that level of recognition has gone up, so there are now clear provisions to prevent, or at least try to prevent, patenting of what is in effect traditional knowledge.
However, the question that was asked about then, what happens if some Western company exploits it? I suppose the question you'd have to ask yourself is, how did the Western company get access to the information? Because trade secrets, for example, does not prevent reverse engineering. So if the Indian company or the Indian community exported their product, so for example, the UK, and somebody in the UK bought that product and then reverse engineered it, that is not trade secret theft. So you've got to ask yourself the question, how did the Western entity get their hands on it? If they stole it, then clearly it's trade secret theft.
Absolutely.
But if they come up with the idea themselves completely independently, or they reversed engineer it, it wouldn't be trade secret theft.
Correct. And Donald, just to close the loop on that, if I may add, nowadays traditional knowledge is also protected under the umbrella of the Convention of Biological Diversity, the Article 8 provision. So India, for example, has a separate legislation called the Biological Diversity Act 2002. And so foreign entities who want to access traditional knowledge must take necessary regulatory approvals. And that regulatory approval process typically ensures that there is some kind of a benefit sharing obligation there. So to a large extent, whether or not it is a trade secret, it is indirectly regulated now in India.
Good.
Okay. So if I understand from Donald and others, so suppose some of the traditional information is not under the biodiversity, but suppose the handicraft or something else, those kind of traditional. So what is the best way to protect those things? Is it by the trade secret or by the GI? As Donald has given the example of the group of monks, they may be residing in a certain area. So what should be the good way to protect those kind of informations?
You go ahead, Donald.
Well, I think in certain jurisdictions there's respect for geographical indications, but there's also parts of the world where I'm concerned that they're not properly respectful of GI protection. There clearly are some disputes at the moment in the world. I think, for example, if you compare the US and Europe, the US is challenging some of the GI protection in Europe. And so I admit GIs have improved considerably in recent times, and there's much more awareness of them. But even to get GI protection takes a lot of time and energy. It is a big challenge to get formal GI protection. So that's a good question. Which one is best? I think you'd have to almost look at it on a case by case. Trade secret protection can work, but then you've got to realize you've got to keep it secret. And you've also got to understand the limitations of trade secret. Like I said, it doesn't prevent independent creation, and it doesn't prevent reverse engineering. So whereas GI is more like a registered form of IP in that regard. It allows you to stop somebody else. So there are pros and cons to both, but I'll pass over to Adarsh in case he wants to make any comments.
Yeah. Thank you, Donald. See, I think we have to realize what is the subject matter of protection in trade secret versus GI. In GI, the subject matter is the right or the ability of someone to apply that GI. I mean, I'm a South Indian, so I'll give you an example of Kanjipuram sarees, right? When you get a GI, or when you're talking about an infringement of GI, it's simply a question where a product is being sold in the market with the application or the name on the packaging saying it is Kanjipuram, when in fact it is not. So the subject matter is the application of or a statement or a misstatement as to the origin, right? In trade secret, it's not about the origin. The question is whether there has been theft or there has been misappropriation. So frankly, I think these are entirely different subject matters. Now that said, they work in tandem, in my opinion.
Yeah, just to add one more point, Pinaki, if I may add, I agree with Adarsh. It will depend on actually the subject matter. The reason being, in certain cases, you may want to have a trade secret protection as well as file a GI, because those are different aspects which gets protected. Just to give you an Arthur example, if the composition is really a trade secret, I'll want to maintain it as a trade secret, but I will brand it differently, which I can always do. but I want to probably keep the composition as a trade secret. So sometimes it's a combination, sometimes it will depend on the subject matter.
Now, these questions has come to my mind only because that when Donald has told that suppose a product which is a trade secret here in India has been sold to any European country or Western country, and there that they have reverse engineering and they have found out that what are the ingredients are, and then that is not a trade secret theft or trade secret something. Now, for the greater provision of that kind of scenario, where the reverse engineering can be a legal thing, whether GI can give a better protection. GI combination of GI and trade secret. That's why that's my question.
But Pinaki, even if you get a GI protection in a situation like that, assuming you get a GI protection, say in England where this is being reverse engineered, all that it precludes them is that the entity or the commercial entity in England is prohibited from putting that name.
Yeah,
It
yeah.
doesn't mean that, but otherwise they can sell the product under a different name without putting that GI, and they can do so legally.
Yeah, got it. Thanks.
Yeah.
So so I will go to the next questions because the time is limited.
Yeah.
We can discuss into that one. We can have another webinar on those part. The next question is from Mr. Gagan Sharma. That what action we can take when a trade secret is misappropriated, and what authority has a original jurisdiction to entertain the case related to trade secret misappropriation. This question is for others, but anyone can answer that.
Okay, I think as I said, you can have a civil action for injunction on damages that will typically go to the relevant civil court where the cause of action has taken place or where the defendant resides. It could be the district court or it could be the high court depending on the value of the suit. If it's criminal, then of course you go to the local police station and file a complaint. If it is the Information Technology Act, in addition to filing a police complaint, there are specified adjudicating authorities appointed at the state level under the Information Technology Act where you can seek compensation. Yeah, I mean, that's more or less the jurisdictional aspect. And as I said, civil remedies, criminal remedies, and compensation, that's really what you're looking at.
Okay.
One thing I'd like to add, there have been a number of court cases, particularly in the US, where people have started taking action and they've lost the case because when they went to court, it was clear that the information was not a trade secret. So I would say to anybody who is about to go into to sue somebody else, they need to look in the mirror and really ask themselves the question: is the information that they believe that has been stolen, does it actually qualify? Can they explain to the court that the information is secret, and what steps have they taken to keep it secret? Is it valuable? So are they able to put a valuation and explain their valuation? And thirdly, are they able to explain what reasonable steps, administrative, legal, and technical, they took to protect it? But I've been amazed at how many court cases there are, particularly in the US, where people have gone to court accusing the defendant of stealing the trade secret, and it's clear that the information was never a trade secret because they failed the basic tests. So it's often easy to accuse somebody, but it's, as been mentioned a few times in the presentations, it can be much more challenging to prove it.
Okay.
If I can jump in here quickly, Pinaki. I'm sorry, I think my connection was weak and
Please go ahead.
I was not able to complete it. But let me quickly jump. One of the things in litigation that we face, and I had actually it was a part of my slides. In fact, in one financial services case that came during pandemic, was one of the employees who was working remotely had downloaded certain source code of the company, and our law firm, one of the partners, actually went to the police station to lodge a complaint under IT Act and of course Indian Penal Code. But the most important thing was when the police officer said what was a misuse of that trade secret, what is the valuation of that. So these are the things which again are very difficult for the trade secret holder to prove the misuse of it. So we were actually when the employee had downloaded the source code into his own pen drive, but did he give it to Ed? this source code to someone else was something that my client was not able to prove, though there was an FIR registered. But at the end of the day, what is the value of that source code? Though this software was developed from last 18 years continuously, so we'll face little tough challenges in the court. The accused have been given a bail, but it's not that easy under the penal laws to actually prove the violation of the trade secrets, because how do you value it at the end of the day?
Okay. Yeah. So there is a couple of more questions. Hello. Can you mute one of you? Hello. Yeah, there are a couple of more questions in this. I'll just name that one, but I think you have understood by this time that Mr. Jeet Shah, he has asked about that when the Trade Secret Act will come in India. We will answer that one in future course of action, and others has already mentioned in his presentation that there was a discussion onto that one and why it is not been becoming the act till now in India. Rima Ghosh has asked the question about the trade secret, how the small businesses can use the trade secret. I think Rima has already got his answer on that. And Saini Singh, he has written that how we can register the trade secret. Unfortunately, we cannot register the trade secret with any government protection. Kashmira Parihar asked about that how to file a trade secret, the same thing, that we cannot file or register the trade secret with the government like patent or copyright. Dr. Nina Sethi asked about the remedies for the misappropriation of a trade secret. Others, you want to answer to these?
I think I covered it in my talk, but basically you can get an injunction, you can get damages, you can get search and seizure of any goods that have been produced in violation of the trade secret. Those are typical remedies, and depending on if you're able to prove criminality, then there's jail term and fine.
And that's pretty much the same in most jurisdictions. It's as just described there. They're the remedies.
Okay, thank you. Then the questions is from Somnath Das about that how the trade secret related to the Indian Contract Act, and Mr. Janil Shah is asking about what is the good piece of evidence when dispute the breach of NDA.
As I said, trade secret is related to the Indian Contract Act in connection through the section 27, which talks about restraint of trade. So typically that's where the overlap comes in, but otherwise trade secret can stand independently. To the other question, what is a good piece of evidence to dispute breach of an NDA? Well, classic defenses that I've seen is number one, independent development, that I did not misappropriate, I always had it. Two, and or my actual process or method is different from what is being claimed as a trade secret. This is also something because it's difficult, the burden of proof on the plaintiff is there and it's difficult for them to prove otherwise. And typically the third thing is to argue that the NDA clause in question is excessively broad. I've seen so many contracts where the definition of trade secret or confidential information is so wide that it looks unreasonable to the judge at the first instance. So that's typically another big area of defense. That's it.
Can I just make a comment about NDAs?
Please.
I don't know what the situation in India is, but in many companies in Europe and America, NDAs are like confetti. People sign them without thinking about what they're actually doing. So I'm beginning to notice some companies are going beyond NDAs. So they're not just accepting the other party. So before they share the trade secret with the other party, they insist on an NDA. But now they're going further. They're also auditing the other company to see, are they actually capable of looking after trade secrets? Do they have trade secret employee programs? Do they have trade secret policies? Do they have a trade secret process? Do they have trade secret management systems? So I know of some companies in the US and Europe who won't just depend on the NDA. Yes, they'll sign the NDA, absolutely. But they will also go further and say, can you explain to me how you're going to look after my trade secrets when I share them with you? Can you tell me about your policies and processes and so forth? I know a German company has been doing that with some of its key suppliers, and I know some US companies are doing it now. So they've realized that, unfortunately, many people sign NDAs without actually thinking about what they've just signed. And there's this common complaint that it's like confetti. I don't know what it's like in India, whether the same sort of culture exists, but clearly in Europe and the US, there is this sort of culture of not treating NDAs with respect.
Same thing applies here, Donald.
Okay.
Okay, so I think other questions are more or less repetitive. If anyone wants to ask any question, please raise your hand. We can. Any more questions that anyone wants to ask? Okay, actually we are now 4:40.
I can quickly answer Mr. Vijay Kumar Sinha's question.
Yeah, please go ahead.
Yeah. Mr. Vijay is asking what is the original jurisdiction for the case related to trade secrets. I think this is where actually the violation takes place. That court will have, or that area will have a jurisdiction. Or if it is defined in a contract itself, if there is an NDA contract, you define a particular jurisdiction, that particular courts will have the original jurisdiction for a case related to trade secrets.
However, I would just like to add an additional point to that. One needs to be very careful about the US. The US doesn't think their trade secret law has got this extraterritorial dimension. And I think the US authorities, they don't really care where the trade secret theft takes place. If there's a link to the US plaintiffs are very anxious to hold a court case in the US. So for example, if you look at the AMSC versus Sinovel case, which involved the theft of software code in Austria in Europe, but the case is actually in New York in federal court, because the US, I know sometimes they think very strongly about the border, but when it comes to trade secrets, they don't really think about the border. If there's a link to the US anywhere in the world, they'll try to get you in US court. And I think Indian companies, just like European companies are getting worried about the US law, I think any Indian company that has some direct or indirect relationship with the US needs to be concerned about the power of the US law. But I agree with you in general, but except for that one exception, I think the US federal trade secret law is very powerful.
Yeah, exactly. I think this is what the defense that TCS took in the court, saying that the theft, if at all, took place in India, and they were burdened with more than $100 million of damages in the case in US. They call it a long arm principle, the long arm jurisdiction of US courts, where they would use the long arm to say that, okay, the theft, the crime took place somewhere else in the world, but the US courts have that jurisdiction with them. So surely I agree with you to be more careful in your contracts, especially when you're handling a US company.
Thank you. Thank you, everyone. Now we are close to 4:30. We need to end the sessions. So we have taken notes, all the questions. I am sorry that I cannot ask more questions now onwards. We can give, if you have registered, I think your email ID will be with us. We will try to give all the answers in the question answer form to all of you in the through email. Okay, so from IPH here, NUJS, I'd like to thank everyone, all the panelists, Mr. Donal, Mr. Shubhadeep Sharkar, Mr. Dinesh Jitwani, and others. Thank you for you giving us your precious time here. Now, so in the concluding remarks that I say is that trade secret is one of the most important things which has been ignored till now. And as a IPA chair, we will take it up, and there will be in-depth sessions. Like today, we have only discussed about the financial sectors, fintech, but we are thinking that we can go to every industry sections in depth for this trade secret aspect. Another thing that we actually believe that because every year you see there is a ranking on the IPR awareness or IPR regime on the worldwide, where India rank is coming not good, primarily because the most of the weightage was on the patenting side. But because of the industry in 25 to 30 years, what I believe strongly is that majority of the Indian innovations and Indian process innovation basically is kept under the trade secret by the majority of the company. So where the value of the Indian knowledge base is lies. So we are also working. We're going to work onto that one. So from the IPH chair, thank you everyone for this one, and I promise there will be a much more webinar on the trade secret part, much in depth. Today, you have all of you have got glimpses of the importance of the trade secret from all of our panelists. So thank you very much. So Jayanta.
Yeah, sir. From the side of the IPR chair and from the side of the IP-Think-Tank, I really thankful to all the participants and our panelists. With that, I just make one announcement to the participants. Those who have already registered, we have your mail ID, and you will get your certificates as we have promised to it, and it will become very soon.
Jayant, just before conclusion, just I want to hear just one line from each of the panelists, starting from Donald. Donald, yes. Before closing this session, if you want to say something, please go ahead.
Well, first of all, thanks again for inviting me. I've been delighted. I've been impressed with the organization. I'm really honored to be on a panel with these other distinguished gentlemen. I hope the audience have gained from this, and I think the point that was made that trade secrets are important. Yes, it doesn't mean that the other forms of IP aren't important. Patents, trademarks, copyright, and all the other forms are also important. But I think in a company developing an IP strategy, they've got to ensure that there's a trade secret component. I think law students who are thinking about their careers and saying, well, will I focus here or here or here? It's worth considering giving a very strong focus to trade secrets, because the trend at the moment is that this form of IP is growing in importance, not just in one location, but across the world. So I wish all of the students who attended best of luck in their careers, but thanks again.
Thank you. Others?
Thank you for the opportunity, and hope the session was useful and insightful. I look forward to more such discussions. Thank you.
Thank you. Shubhadeep?
Yeah, thanks to everyone for giving me an opportunity, and it was very insightful to listen to the other panelists as well. There's always a learning in these sessions, so I'm grateful for that, and I think it was a good interaction, good questions. So thanks a lot.
Thank you, Dinesh.
Yeah, just a big thanks to all the organizers, Dr. Pinaki, yourself, and Jayanta for inviting me. And I think this is what I have been voicing from last 2 decades in different organizations, that trade secrets are extremely important, perhaps sometimes more important than your patents and trademarks. So thank you for giving me a voice on this platform to repeat what I've been saying. Thank you so much.
Thank you. Thank you very much. Okay, we can now close. Thank you very much.
Thank you. Thank you. Goodbye.
Everyone.
Bye.
And from the side of the organizing team, thank you to our volunteers, Bhaskar, Abhishek, and Jagannath, Chandrika, and other 2 is another set of Pinaki sir, Rima and Vishwajit. We'll look forward this kind of session. All the panelists also will look forward to add you in another events in future. Thank you all the participants.
Thank you.
Thank you.
Thank you. Bye.